Welcome. This is the court visitor training video for the state of Oregon. I'm Senior Judge Rita Cobb. To my left is Judge Lauren Holland from Lane County, and to my right is Judge Claudia Burton from Marion County. This video is an introduction for those individuals who wish to be appointed to serve as a court visitor in protective proceedings. We'll be presenting the administrative legal portion as well as an overview of various mental issues you may see in your assignments. Now, because the instructions that we're presenting are for court visitors statewide, the information will be based on the requirements of the Oregon Revised Statutes, Chapter 125, and the Oregon Uniform Trial Court Rules. There may be additional specific rules and requirements in the county where you're appointed on a case. To be sure to check with the court administrator or person in charge of the protective proceedings in the county where you're appointed to determine whether there are any additional requirements in your case. In the legal and administrative portion of the video, we'll be providing the legal process in a protective proceeding, an explanation of the court visitor's interview requirements, the requirements of the court visitor's report that's filed with the court, the process in emergency temporary protective proceedings, court hearing and the visitor as a witness, as well as tips from a court visitor. We'll now have Judge Holland talk about the legal process in a protective proceeding. Judge Holland.
Thank you. Thank you for your willingness to act as a court visitor in these proceedings. We're going to talk about some definitions. Words that you use in these protective proceedings are important. Many of you have backgrounds in medical fields or in mental health fields. What you're going to be using are legal terms, however, and they have very precise meanings. We are talking about protective proceedings which include guardianships and conservatorships. One of the first things to think about is to make sure that anyone that you are speaking with understands what you mean by those terms and you understand what they mean. Each state has a different way of talking about protective proceedings. In Oregon, a guardianship is talking about a person who decides questions of the welfare, the residence, the care and comfort of a person who is ultimately a protected person. A conservatorship deals with the person's assets, their financial matters. Other states use these same terms, guardianship and conservatorship, to mean other things. And therefore, one of the first things I would ask is when you speak to someone who is from another state or lives in another state, to make sure that they define for you what they mean when they talk about a guardianship or a conservatorship, because it may be very different from what we have used in Oregon. The term respondent means a person for whom entry of a protective proceeding, that is a guardianship or conservatorship, is sought in a petition that's filed under these statutes. A person remains a respondent until and unless the court orders that a guardianship or a conservatorship be put into place. At that point, and only at that point, do they become a protected person. So it's the same person. They are a respondent up until the time that an order or a judgment is signed by the court that appoints a guardian or a conservator, and then from that time forward, they become a protected person. When we talk about guardianships and conservatorships, as I said, we're talking about either the welfare of the person and decisions about that, or the person's financial assets and their financial management. In order to have a guardianship or a conservatorship, the petitioner, which is the person that brought these proceedings before the court, needs to prove certain things. In a conservatorship, the respondent needs to be proven by clear and convincing evidence to be unable to manage their financial resources effectively based upon either a mental illness, mental retardation, physical illness or disability, chronic use of drugs or controlled substances, chronic intoxication, confinement, detention by a foreign power, or disappearance. Managing financial resources means those actions necessary to obtain, administer, and dispose of real and personal property, intangible property, business property, benefits, and income. These matters are defined by statute. When we're talking about a guardianship and what needs to be proven, again, by clear and convincing evidence, the person needs to be proven to be incapacitated as set out by statute. And that means a condition in which the person's ability to receive and evaluate information effectively or to communicate decisions is impaired to such an extent that the person presently lacks the capacity to meet the essential requirements for the person's physical health or safety. Please note that we're talking about presently lacks the capacity. A guardianship is not a planning tool. It's not something to put in place for the future when someone may lose their capacity. It is only to be put in place when the person presently lacks the capacity to meet the essential requirements for that person's physical health or safety. The definition of meeting the essential requirements for physical health and safety is that those actions necessary, and includes those actions necessary, to provide the health care, food, shelter, clothing, personal hygiene, and other care without which serious physical injury or illness is likely to occur. You may be appointed to investigate as court visitor, write a report, and then make a recommendation to the court with regard to proceedings of a guardianship or a conservatorship, with regard to a respondent who is a minor or a respondent who is an adult, and with regard to what's called a temporary guardianship or conservatorship, and generally those are emergency types of situations, or an indefinite guardianship or conservatorship. Let's look at an overview of how this happens. If you look at the life of a guardianship case, the way this comes to court is by a filing of a petition. And that petition requests that the court appoint either a guardian or a conservator, or both, for a respondent. Upon the filing of this guardianship, and that's what we're going to talk about here, a court visitor is appointed in most cases. In all cases where the respondent is an adult, and the court may appoint when the respondent is a minor. There are certain times at ages 16 and 17 when the respondent will turn 18 that a requirement of appointing a court visitor is also necessary, and that's by statute. The court visitor will file a report after having done an independent investigation, talking with certain people, including the respondent in person, the posed fiduciary or the proposed guardian in person, and other people, sometimes in person, although some that may be by telephone. And there will be further, Judge Burton, I believe, will be talking with you about those types of interviews and the investigation. And then the court visitor will write a report. And that report has different time frames depending on whether this is a temporary or emergency guardianship or an indefinite guardianship. If no objection is filed to this petition, the court may sign what's called a limited judgment, appointing someone to act as guardian for the respondent, who now becomes a protected person. If an objection is filed, then the court will hold a hearing. The court may appoint an attorney to represent the respondent during the course of this hearing, and you may make a recommendation as part of your report to whether or not you believe it would be appropriate and of assistance to have an attorney appointed to represent the respondent. The court visitor must be present at that hearing, and that's also by statute. The court would then determine if there is a hearing, whether or not, by clear and convincing evidence, that there has been proven that the respondent is incapacitated, as defined, that the appointment of a guardian is necessary as a means of providing continuing care and supervision of this person, and that the proposed guardian is qualified and suitable to serve. The guardianship needs to be as least restrictive as possible. We're talking about the liberty of the protected person, and we are attempting to ensure that there is no more restriction on the liberty of the protected person than absolutely necessary. That's also set out by statute. If the guardianship is granted, letters of guardianship will issue. The guardian has certain statutory authority and obligations that must be met. If during the course of the guardianship, at any time, the protected person or any other interested person objects to any of the actions taken by the guardian, then a hearing may be scheduled and held. At any time after the appointment of a guardian, the court may also appoint a court visitor to do another investigation and file another report, upon which the court may choose to hold a further hearing. The life of a conservatorship case. A conservatorship case also begins with the filing of a petition for conservatorship. A petition may also request both a guardian and conservator. Upon the filing of a petition for a conservatorship, a court visitor may be appointed. Again, if you're appointed, it's really what your job is to conduct an independent investigation on behalf of the court regarding the need for a conservatorship and the suitability of the proposed conservator. You would be conducting the independent investigation and then writing a report, submitting that report to the court with a recommendation, and then the court will, if there is an objection, hold a hearing with regard to this matter, at which time you as court visitor would need to attend. And if the matter was proven by clear and convincing evidence, then a limited judgment appointing a conservatorship would occur. If the petitioner does not prove by clear and convincing evidence that the respondent is financially incapable and that the proposed conservator is appropriate to be appointed, then the court will not appoint this conservator. If in fact the petitioner proves those two elements, then the court will sign a limited judgment appointing a conservator. If the conservatorship is granted, letters of conservatorship will be issued upon the filing of a bond. The conservator, again, has statutory authority and obligations that must be met. If either a protected person or another interested party objects to any of the actions taken by the conservator, then a hearing may be scheduled and heard by the court. At any time after the appointment of a conservator, the court may appoint a court visitor. The decisions that are being made by a guardian with regard to the care and welfare of a protected person include such things as where the person will live, whether or not they must be subjected to certain medical procedures or treatments, who the person is entitled to see, what visitors they may see, and potentially end-of-life decisions. With regard to a conservatorship, the conservator is making such decisions with regard to the assets of the protected person and the income and payments on behalf of the protected person. You are an important part of this process. The court appreciates your willingness to act on behalf of the court to investigate, to write a report, and then make a recommendation to the court, which may or may not be followed ultimately by the court, but is certainly an important consideration among other things that the court hears in making a decision about these protective proceedings. We're now going to hear from Judge Cobb again, who will talk with you about temporary protective proceedings. Judge Cobb.
Thank you. In addition to the indefinite guardianship and conservatorship cases that Judge Holland has just discussed, from time to time you may be appointed to serve as a visitor in a temporary proceeding. In a temporary protective proceeding, it's important to note that all of the requirements for an indefinite guardianship and conservatorship apply to the temporary proceeding, with some of the exceptions that I'll discuss. First, in a temporary guardianship proceeding, the statute requires the court to make specific findings by clear and convincing evidence that the respondent is incapacitated, that there is an immediate and serious danger to the life or health of the respondent, and that the welfare of the respondent requires immediate action. Likewise, in a conservatorship proceeding, the findings must be that the respondent is financially incapable, that there's clear and convincing evidence that there's an immediate and serious danger to the estate of the respondent, that's their property, their finances, their income, and the welfare of the respondent requires immediate action. Now, because of the emergency nature of a temporary proceeding, the statutory requirements of notice are shortened to only 2 days instead of the 14 days in an indefinite proceeding. In addition, the statute gives the court the discretion to waive that 2-day notice if there are specific findings that the immediate and serious danger requires immediate appointment of a guardian or conservator. Another important difference in a temporary proceeding are the limitations placed on the authority of the person appointed as guardian and conservator. If the court determines there's clear and convincing evidence that requires the appointment of the fiduciary, the statute also requires the person can only be appointed for a specific purpose and for a specific period of time. The authority of a temporary fiduciary cannot exceed 30 days. Now, the court does have the discretion to grant an additional 30-day extension. However, that would be considered at a later time, and it's based on a motion, and the court would have to make a finding that good cause has been shown to grant the extension. Now, again, looking at the emergency nature of the proceeding, the court visitor deadlines are also affected. The visitor is required to interview the respondent within 3 days after the appointment of the fiduciary, and the visitor is required to file their report within 5 days after the appointment of the fiduciary. Now, as you can see, the temporary proceeding, the timelines are greatly accelerated for the visitor's inquiry into the case. And even though the time is short for the court visitor, the scope of the inquiry is also limited by the statutes. The statute requires the report of the visitor to be limited to the conditions alleged that support the appointment of the temporary fiduciary. Now, what does that mean? First, the focus of the court visitor in a temporary proceeding is the immediate and serious danger to the respondent that's alleged in the petition. What's the specific danger to the life or health of the respondent? And is the danger immediately? Second, considering the limited powers of the fiduciary, is the guardian or conservator qualified, suitable, and willing to serve in the temporary capacity? Now, if objections are made to a temporary proceeding, the court is required to schedule a hearing within 2 judicial days after the objection is filed. If you're appointed to a visitor in a temporary case, you should remain alert to the possibility that a hearing is going to be set on a very expedited basis. As a practical consideration, if you're contacted to serve as a court visitor in a temporary proceeding, you should be sure your schedule can accommodate the accelerated time requirements for the interviews and the filing of the reports, and that you would be available to appear at any hearing the court may schedule. Now, Judge Burton is going to be talking about the interview process and the visitor's report. Judge Burton.
Thank you. So as a court visitor, your role is to serve as a disinterested third party to investigate and to make recommendations to the court. The visitor should not have any personal knowledge of or personal interest in any of the parties to the case. You should decline appointment if you are asked to serve in a case where you know any of the parties. Once your report is filed, your investigatory role is finished unless you are reappointed by the court. Let's talk a little bit about the investigation that you'll need to conduct. The first thing is you'll need to interview the respondent. The respondent must be interviewed in person and must be interviewed where he or she is located. When you arrive on that scene, if the situation is dangerous in some way, for example, the respondent or someone else on the premises is threatening, then leave and call 911 or else the attorney that asked you to serve as a court visitor. We do not want you to place yourself in any kind of danger. If you arrive on the scene and you see conditions that appear to be dangerous for the respondent, for example, feces on the floor, moldy food and dishes sitting in the sink, no food in the refrigerator, drugs on the premises, and this is a case where there is not a petition for a temporary guardianship, then you should report immediately to the attorney for the petitioner that a temporary appointment is needed. And you also should report to the police in that situation. Depending on your licensure, you may be a mandatory elder abuse reporter. For example, if you're a social worker, a licensed professional counselor, a nurse, a psychologist, or an attorney. And in that case, of course, you need to act consistently with your responsibilities under the elder abuse reporting statute. It's important that you insist on meeting with the respondent alone, at least briefly. Sometimes the respondent may appear to be more comfortable with other family members or friends around, and that's fine as long as you have a few minutes where you're certain that you're able to speak to the respondent without the respondent being influenced by anyone else that's present. It's also important that you see the respondent personally, even if the respondent is completely unable to participate in an interview. For example, they're in the hospital in a coma. The court still needs you to verify that for us. Otherwise, the only information that we have is the petition filed by the petitioner. So we need you to confirm for us that that is in fact the case. You've been provided with the statutory definition of incapacitated. I want to talk to you about some of the factors that you might consider in determining whether a person is incapacitated. You want to look at medical factors. Can the person physically meet their essential basic needs? Can they get to the bathroom? Can they physically take their medication? Can they physically eat meals? You also want to look at cognition. In general, does the person know where they are, what time of the year it is, who their family is? Do they understand any medical conditions they have? Do they know when they might need to go to the doctor? Are they capable of making an appointment and getting themselves to the doctor? Is the person cognitively capable of understanding their medications and when they need to take them, especially ones that might be critical, like insulin? Are they able to prepare food or otherwise obtain meals? Then you want to take a look at everyday functioning in terms of what you are able to observe when you're there. Is the residence sanitary? Is there nutritious food in the house? Is the respondent able to show you his or her medications? And does it appear that the medications are being taken? For example, you can look at the prescription bottle and see the date the prescription was filled and how many are supposed to be taken. And you can actually count and see how many are left and see whether they're being taken as prescribed. These everyday observations will be most important, of course, if the respondent is still in his or her own home. If you go to see the respondent and they're in a facility where they're being cared for, then those observations won't be as important because they won't be functioning independently at that point. You also want to look at the protected person's values and preferences and how those might factor into their current situation. For example, they may not be taking medication because they have been opposed to taking medication for religious reasons their entire life. Or you may have someone who is suddenly married to a same-sex partner when they previously never had a same-sex relationship before, and so you might be wondering what is going on there. You also want to look at what kind of supervision is available, what kind of means are available to enhance that person's capacity or make it possible for them to remain at home if that's where they want to stay. For example, are there supports like Meals on Wheels? Can they have a personal care attendant to assist with bathing? And then you also need to look at not only are there supports that theoretically could exist, but are those supports actually available in the community? Can the person afford them? Can they be obtained as a practical matter? Or alternatively, is this someone who really does need to be in a locked facility because they're wandering at night and they're knocking on their neighbors' doors at 3 in the morning? With regard to conservatorship and the financially incapable standard, you can look at such things as, do they know the sources of their income and the amounts of their income? Do they know what bills they have? Can they show you their checkbook? Are there a bunch of unopened bills or sweepstakes entries sitting on the kitchen table? Is there evidence of unusual bank withdrawals? And this kind of information may come from family members or bank employees. Has the power or water been shut off or insurance canceled due to failure to pay a bill? Are they sending money to a Nigerian prince or a Russian girlfriend? You will also be interviewing the proposed guardian or conservator. That person also needs to be interviewed in person. What you're looking for there is the nominated person qualified, suitable, and willing to serve as guardian or conservator? Can they do what needs to be done? And sometimes those are difficult things to do. If mom wants to stay home but she really can't, is the nominated guardian going to be able to say no to mom? If mom is being financially or even physically abused, perhaps even by a family member, is the proposed guardian or conservator able to take the necessary steps to get that person out of the environment? Does the proposed guardian or conservator have their own issues which may prevent them from acting in the protected person's best interest? For example, perhaps the proposed guardian or conservator was actually abused as a child by the respondent, and they may not be able to separate the issues they're still dealing with from the protected person's or proposed protected person's best interest. Does the proposed guardian or conservator have a conflict of interest? For example, they may owe the respondent money, or they may be living in the respondent's house without paying rent. Then you also want to interview a variety of other interested persons who might be sources of information. One obvious source of information is physicians and healthcare providers. Now, HIPAA may prevent those people from talking to you about the respondent. Although you are appointed as a court visitor, the statute does not allow you to violate physician-patient confidentiality, but you can ask. You should be sure to address any HIPAA issues in your report. For example, if there was information that you thought would be very important, but you were not able to obtain it for HIPAA reasons, you can address that in the report. And the parties in the court may be able to arrange for other ways to obtain that information or to obtain information from alternate sources. You're not obligated to talk to any of the attorneys in the case, and you should be careful to maintain your neutrality in any contact that you have with the attorneys. And then there's a whole variety of other people that you may want to interview: family members, friends, a pastor, neighbors, anybody that you become aware of in the course of your investigation that might have information. These interviews do not need to be in person. Now let's talk about the report that you're going to be preparing for the court. I want to let you know how important your report is to the court. You are our best source of neutral and unbiased information. Your report is not only important to us in helping us decide whether to appoint the nominated guardian. Of course, in uncontested cases where no objection is filed, your report may be the only information that we receive besides the petition to help us decide whether the respondent needs a guardian or conservator, and whether the nominated person is appropriate. In contested cases, your evidence is often the only evidence from a disinterested party. And oftentimes, your report may help to settle a contested case. After receiving your report, the parties may come to an agreement about what's the appropriate way to proceed. But I also want you to know that the court may look at your report many, many years down the line. For example, when I'm reviewing an accounting that shows money's being spent at Pizza Hut, I may go back to look at the visitor's report to determine, is the respondent somebody who can eat pizza, enjoys eating pizza, or is the respondent somebody who's on an all-liquid diet, in which case I have to wonder who's eating the pizza. I've looked at visitors' reports when a family member surfaces and wants to become the substitute guardian. I've looked at a visitor's report to see that there's a family history with this family member, and there might be reasons in the past why that person might not be appropriate as a successor guardian. Just this year, I wound up looking at a visitor's report that was 20 years old, where I had a case where the protected person had been making loans to the conservators. And I needed to look back at not only what was the family history, but what was the capacity of the protected person to understand these kind of transactions. So your reports are so critical to us, not only at the moment when we're deciding whether to appoint a guardian or conservator, but throughout the life of that case. There is a form for the court visitor's report, and it is set out in the Uniform Trial Court Rules, and you have a picture of that form in your slide. Some counties will also have an additional form or require more detailed information. For example, Marion County does. So you do want to look at what your specific county requires, but otherwise you'll use the standard form that's in the Uniform Trial Court Rules. Some of the things that you'll need to address will be a statement regarding whether the allegations of the petition are correct, whether the appointment of a fiduciary is necessary, and this will include both whether the respondent meets the statutory definition of incapacitated or financially incapable, as well as whether other less restrictive means might be sufficient so that we don't need a fiduciary appointed. For example, Meals on Wheels or an advance directive. One important thing to know in considering whether a less restrictive alternative exists is that if a person is being financially exploited, really only a conservatorship can prevent them from giving their money away. So if the person's problem is they're not able to balance their checkbook or handle their bills, that's something that perhaps can be handled through a power of attorney or a trust. But if they're being financially exploited and giving their money away, a conservatorship actually legally deprives them of the ability to make a contract or give their assets away. And so that is really the only thing that will help in that situation. Your report also needs to list the name, address, and telephone number of each person that you interviewed. And your report needs to explain whether the respondent expressed any objections or any expressed desires as to whether they might like a different fiduciary, whether they don't like that proposed fiduciary, and also whether they want a court hearing and whether they want to attend a court hearing. It's very important that the information in your report include a narrative about the information and facts that support your recommendations. Please give us the underlying facts, not just your conclusion. So for example, if you tell us the respondent was unable to understand that she's required to monitor her blood sugar and administer insulin, and although she is a brittle diabetic, her kitchen was filled with cakes, cookies, and desserts, and little nutritious food, and she's incontinent and unable to care for this, so I found urine stains and smells on her couch and mattress. That gives the court a lot more to go on than if your report just says the respondent is incapacitated and needs a guardian. Your report is required to be filed within 15 days of the date of your appointment by the court and 5 days if there's a petition for a temporary guardian. If you need additional time, you may file a petition with the court to request an extension of time to file your report. Anyone requesting a copy of the report must contact the clerk of the court. You, as the court visitor, do not have any obligation to provide anyone with a copy of your report. If your report includes confidential information from the Department of Human Services, and you should understand that the Department of Human Services includes, for example, Adult Protective Services, then by statute, and the statute is ORS 125.012, subsection 4D, the statute requires that that report is not subject to inspection by the public. And then ORS 125.0124C addresses that part. The Uniform Trial Court rules also restrict the access of parties and their attorneys to the report. Uniform Trial Court Rule 9.410 requires a person submitting confidential information to also submit an order. And that order is in the appendix of forms to the Uniform Trial Court Rule. It's form 9.410.1, and there is a picture of that form on your screen. And the rule also requires the person submitting that information to serve the order on the parties to the case. In Marion County, the court will send that order to the parties. And now Judge Cobb is going to talk to us about the hearing process.
Thank you. If an objection is filed in a protective proceeding or any other number of reasons, the court may set a hearing in the case. The court visitor may then receive notice to appear at the court hearing. And it's important to note that the statute requires the court visitor to be present at any hearing set on an objection to the appointment of a guardian. You should receive notice of the hearing from the attorney for the petitioner, and in many cases, the court will contact the court visitor to ensure they know the correct date and time set for the hearing. Now, in preparation for the hearing, you'll want to be as accurate as possible in your testimony regarding the case. To that end, you should have a copy of your visitor's report and any notes or other information that you may find useful in refreshing your memory with regard to the case. In a hearing, it's not uncommon for the witnesses who will testify at the hearing to be excluded from the courtroom, and this may include the court visitor. A notice is usually posted on the door of the courtroom to notify the witnesses that they cannot enter until they're called to testify. Now, so when you arrive at the courthouse, you should check in with the court staff to let them know that you're present, and at that time you can ask to be informed about whether or not you'll be allowed to sit in the courtroom or whether you need to be in the hallway. Evidence is presented at every court hearing. It's either testimony or exhibits. Testimony is presented by a witness who's under oath and testifies regarding to the facts relevant in the case. Exhibits are documents or other physical objects received into evidence by the court. Now, all protective proceedings are hearings that are before the court, which means that a judge, not a jury, will decide the case. The general procedure in a court hearing is that the attorneys representing the parties will first make an opening statement to the court. An opening statement is not evidence. It's what the attorneys believe the issues are, what the evidence will show, and what they believe the outcome should be. Now, the person who's filed the petition presents the evidence in their case first. The petitioner, as you've heard, has the burden to prove by clear and convincing evidence that the respondent is incapacitated or financially incapable, that they need a guardian or conservator, and the person nominated is qualified, suitable, and willing to serve in that capacity. Now, the burden of proof is important because the respondent does not have to prove that they have capacity. There's a legal presumption that the adult respondent has capacity unless it's proven otherwise according to our statutory definitions. Now, the party who calls a witness to testify is the first to ask the witness questions. This is called direct examination. And when they're finished, the opposing party then has the opportunity to ask the questions. This is called cross-examination. After that, the judge may ask questions or allow the parties to ask further questions of the witness. So after everyone's finished asking the witness questions, the witness may be excused. However, if one of the parties think that they may want to ask the witness questions later, they may ask the witness not be excused. So it's very important that you not leave the courtroom until you're clear that the judge has in fact excused you from the hearing. After the petitioner has presented all of the evidence in their case, the respondent then has the opportunity to present their evidence, and the same process of direct and cross-examination applies to the respondent. Now, after all the parties have presented their evidence to the court, both parties then are allowed to make closing arguments to the court. Again, closing arguments are not evidence. It's the opinion of the attorneys regarding what they believe the evidence that was presented has proven, what they believe the applicable law requires, and what decision they believe that the court should make in the case. At the end of the hearing, the judge may make their ruling from the bench, or the judge may also take the case under advisement, which means that they'll usually make a decision later, and it's usually in writing. Now, when you testify as a court visitor, you should listen carefully to the questions from the attorney. If you don't understand the question, ask the attorney to repeat or clarify the question. In answering questions, you should be as accurate as possible, but don't guess or speculate on an answer. And if you don't know what the answer is, it's okay to say, "I don't know." At times during your testimony, an attorney may raise an objection to the court. If the attorney objects, you should wait to answer the question until after the judge rules on the objection. If the judge sustains the objection, you cannot answer the question. If the judge overrules the objection, you can then proceed to answer the question. And if you need the question to be repeated, you can simply ask the attorney to repeat the question for you. If during your testimony you need to refer to your notes, you can ask the court if you can refresh your recollection by referring to your report or your notes. And at times, after you've refreshed your recollection, the attorneys may ask to view the notes. You need to understand that the judge will usually allow the attorney's request in these cases. A court visitor's testimony is important information. As a visitor, you're the eyes and ears of the court. You gather the facts, make recommendations, and may have come to a conclusion in the case. However, at times, you may not have an opinion regarding an issue in a case. For example, there's more than one person who's petitioned to be guardian, and you haven't really formed an opinion as to who is the most qualified to serve. And that's okay. So long as you provide the facts you've found, that you present your observations in the case and any concerns that you have, you've done your job. It's important to remember that the visitor is not responsible for making the final decision in a protective proceeding. At the end of the day, that task is the sole responsibility of the judge. We'll now hear some tips from an experienced court visitor, Mary Sherriffs.
Hello, my name is Mary Sherriffs. I'm a court visitor with Lane County Circuit Court. I have a background in social work. I've been doing this part-time work as a court visitor for about 14 years. It's a wonderful job, and I enjoy it very much. A person gets to meet all kinds of people. As you know, guardianships sometimes involve minor children, sometimes adults with disabilities or mental illness, sometimes elderly people. It's the court visitor's job to make contact with these people and those around them and those caring for them, and to prepare a written report for the court about the circumstances of the guardianship. Sometimes as you may have guessed, families are difficult to deal with. Usually when I make the initial appointment with a family, I try to find out whether or not the respondent, that is, the protected person, proposed protected person, has been notified that this petition has been filed. I usually tell them over the telephone as well that I need to interview the proposed protected person privately. This is especially important in cases where there are little kids. I mean, we interview children as young as 2 years old sometimes, and it is always surprising to me how astute these little kids are. We often, with children, don't use the term guardianship. Sometimes we just say, your grandfathers asked the court for permission to make decisions for you. Is that all right with you? Usually they say yes. Say, do you trust your grandfather? Usually they say yes. All of that information needs to be recorded. When I receive a petition from the court, I review all of the written documents ahead of time before I even start on the case. I always try to interview the protected person before I interview anybody else. Sometimes we're talking with doctors. We are often talking with many family members. We're talking with caregivers. And we're talking with sometimes agency people, like people at disability services. All that information needs to be recorded in the report, and it's important for the court to have that information and for the attorneys involved to have that information. I often ask, one of the things I often ask when I'm in a family situation, if there's anyone involved that has been arrested or has any felony convictions. Sometimes that doesn't have any effect on the guardianship at all, but it could, and that's good information to have. Recently, court visitors in my county have been asking families where there is a child involved about their drug protocols. Are their medications safe? We've also started asking about firearms, whether firearms in the home are safe and protected from the child. I often ask children about whether they have chores in the home and what the names of their friends are. This kind of gives the court a feeling of the overall life of the child. When adults are involved, I think it's important always to get a family history, the names and ages perhaps of other people in the person's family, particularly if they are in the household. I rarely comment on household conditions unless I consider them dangerous. Sometimes people will say to me, I don't want you to come to my house because it's a mess, and I tell them it doesn't make any difference. I'm not going to comment on that. I try to ascertain what the respondent, that is, the proposed protected person, wants. And that is very important because the court visitor is an independent voice for that individual. I've enjoyed this part-time job as a court visitor. I hope you enjoy your new career as a court visitor. Thank you.
That concludes our training video, and I'd like to thank you for your interest and your willingness to serve as a court visitor for the state of Oregon. Your service is greatly appreciated. Thank you.